So with that, with the acknowledgement of country opening our session, I'm absolutely delighted that Professor Steven Vaughan from UCL Faculty of Law is here. He's an absolute star of environmental regulation, in-house lawyers ethics, and in recent years, he's really taken on the challenge of thinking about lawyers' responsibilities and the climate crisis and the environmental crises that we are facing, and what professional responsibilities as lawyers and as educators of future lawyers and of those learning about the law, what responsibilities we have. So he's going to give a mini version of his, what was it? Your inaugural, I'm sorry, I lost my word, his inaugural lecture on this topic. And then we're going to have a bit of a discussion. We've got a few people who are all doing stuff here in Australia on lawyers and professional responsibility and the climate crisis, who are all going to tell us a bit about what they're doing and how we can get involved, what else we should be doing.
Thank you, Christine. Afternoon, everybody. It's a real joy to be back in Melbourne City that I have lots of time for. I've turned up my chinos one more turn to fit in with the men of the city. This is kind of work, Christine, that I've been doing for a year or so, and an ongoing project. So delighted to speak about it. I'm always kind of curious why people do the research that they do, like what's like behind it. And for me, doing this work is kind of cheaper than therapy. So I've been in practice. I sometimes say to my students that I was a bad environmental lawyer, but actually I was really good. I was really very competent at my job, acting for BP and BAE systems, doing all sorts of work. And when I was in practice, I never kind of stopped. Apart from one time that I'll come on to later, to think of what I was doing for my clients. It just wasn't part of the narrative. Well, this work, it wasn't part of the story that I would tell myself about what I was doing, what it meant. And the one time I asked the question, one of the partners simply said, well, everyone deserves access to justice, and that was the beginning and end of the conversation. And I'd like to say that I left practice because I was so enraged at what I was doing for BP and others, but that is not the case. And I will tell the real story over a glass of wine this evening. So what I'm going to do is run through a series of statements that are kind of connected to this current and ongoing project of work. And the first one seems to me really banal and kind of simple and basic, and yet really upsets practicing lawyers when you say they are responsible for climate change and other environmental harms. It's simply factual. So if you think about the work that lawyers do for their clients, raising finance for the purchase of an oil field, helping with licensing, they're kind of pretty obvious ones. But all of the work of solicitors will have some kind of carbon impact, some kind of carbon consequence. And simply saying that solicitors are part of that narrative, part of that story, really is very uncontroversial. And yet, I don't think very much has been done till now, including the people in this room, on that very broad topic, kind of how are lawyers responsible? What does it mean for lawyers to be responsible? And Natasha Affolter in her work talks about the hidden people in environmental law. I think for quite a chunk of time, environmental lawyers or lawyers who contribute to environmental harms have been hidden people. And that's why this conversation, so pleased it's happening, this work is happening. So simple facts, lawyers are responsible. They help to bring about climate change for their clients. There is also all the other stuff that lawyers like to focus on much more. So lawyers like to tell you a story, how they are changing the energy use in their offices, how the kits for their netball team are now being sourced from a kind of more ethical company. And it's sort of very boring, isn't it? Like the carbon impacts, the scope 1, 2, and 3 emissions, the sort of direct, indirect impacts, really, really unimportant. What's much more important is, what are the carbon impacts you are creating for your clients? But for your work, for your clients, would these carbon impacts come about? That being said, there will be situations in which the responsibility of solicitors, other lawyers, for climate change, for bringing about climate change, will be mediated or reduced. I'm going to talk about two of them today. One, professional ethics rules and what they do. In which situations do they require lawyers to bring about these harms for their clients? And then more general ethics after that. So at home, we have a kind of complex regulatory system of professional ethics, 9 different types of regulated lawyer, 9 regulators. For the solicitors, it's the SRA who sets out the code of conduct. And again, I think this is a relatively banal statement, although practicing lawyers don't think it. But when you look at the code of conduct, it seems pretty clear to me that it requires active counselling by solicitors on environmental harms, and that it's a bit more problematic sometimes, also requires solicitors to walk away from their clients in some situations. And this is that broad umbrella, this phrase we're now pretty familiar with, I think, of climate conscious lawyering. Dr. Kim Bua first spoke about this. Justice Preston has really taken this up. There is an edited collection that's happening. Brad, I'm looking at you.
Julia.
Thank you. There's an edited collection going on. This is kind of very much in the psyche now. What does it mean to be a climate conscious lawyer? And if we're thinking about the rules in England and Wales that apply to solicitors, this is the kind of be all and end all. This is the principles that sit at the front of the code of conduct. They apply to everything that a solicitor does. They are not ranked, they are pervasive, etc. And what they tell us is you act in a way that upholds the rule of law, public trust and confidence in the profession, independence, honesty, integrity, in a way that encourages EDI, and in the best interest of each client. And I think, if we had more time, you could forensically go through each of these and think about the ways in which those requirements, those principles, obligate solicitors to think about environmental harms, and more strongly than that, to counsel their clients about the environmental harms that their clients want to bring about. So let's think about independence. Well, independence means independence from the state. That's always been one of the first things that we think about. But as equally important is independence from your client, having those really hard conversations with your client where that is necessary. My knowledge, I'm afraid, of the various states and what happens in Australia is pretty limited. I'm looking forward to learning more. But when I was reading this, it didn't seem kind of ballpark too far away from what we have, with one small gloss I'll come on to in a second. And I was interested to read this in the latest edition of Parker and Evans with Viv and Francesca. This point here, under the Australian ethical conduct rules, the American Bar Association explicitly permit a lawyer to counsel clients on the moral, economic, social, and political factors that the lawyer believes are relevant to the client's situation. We believe this type of counseling in the context of business exposure to climate and biodiversity risk is today simply an aspect of competent lawyering. And I agree, I think that's right. I kind of think there is some interesting work being done at home, and I imagine over here, on the ambit of a lawyer's obligation in tort, maybe also in contract, maybe also as fiduciaries, and what that means. What does it mean to be competent when there is so much knowledge about climate risk? What does it mean to be competent and to advise in your client's best interests when there is so much about environmental, social, and governance issues? Can you be competent if you are not counseling your clients on the environmental harms? Now, when I say this to practicing lawyers, particularly in the largest law firms, one partner in a Magic Circle firm said to me, look, I'm not trying to say what you're saying is pointless, but, which is a very English way of saying something, and he said, look, clients don't care. Clients just don't care. They don't want to hear this from us. They're not interested. Like, they're not paying us for this. They just don't care. And I said, yeah, I don't care. I don't care that they don't care. Because I think this is right. I think you have to have a legal obligation to do it. I think that's the way that the principles work. Now, yes, the regulator will never enforce, come on to that in a moment. And yes, there are issues whether you actually know about any of these rules, you don't. I do a thing which is fun. Whenever I have a room full of practicing lawyers, hey, everyone close your eyes. How many principles are there at the front of the code of conduct? And I give them options, 10, 7, 5, or 3. Never more than 20% of the room gets the answer right. And I reckon most of them are guessing. And then when you go and interview those lawyers, as I do quite frequently, and say, when was the last time you looked at that code of conduct? They say, never. It's not relevant to what I do. That's not relevant for me in my large law firm, the sort of work that I do. One of the things I'm going to do over the next year or so is get into the negligence case law and what the negligence case law tells us about the ambit of the duty of care for solicitors. What is the duty of care in relation to climate and climate risks? When is that duty breached? I'll come back to that in a moment. The thing that I think is a little bit different to how I understand this paramount duty is what's at the very front of the regulators' code in England and Wales. So you have these 7 principles, they apply all the time, they're not ranked, but it does say, should the principles come into conflict, those which safeguard the wider public interest, such as the rule of law and public confidence in a trustworthy solicitor's profession and a safe and effective market for regulated legal services, those take precedence over an individual client's interests. And I just found this really curious. No one in practice knows this exists, apart from the general counsel lawyers who work inside the risk departments. The regulator doesn't really tell us anything. There's no guidance on what this means or how it's engaged. But I think there is something interesting in this. At what point are you creating these significant existential carbon harms for your client? At what point do you take a step back and think, I have some issues with my integrity, with my independence, with the rule of law, with trust in the profession, all of these things put together? I think there is a conflict. When there is a conflict, I'm told that this directs me as to how to act. Is the public interest in that situation going to take precedence? I mean, of course, this is never actually going to happen because there's not the way in which large law firms work, and those of us who do work on large law firms know this. But it is interesting, and I keep on pushing the regulator on this. I'll come back to why that is in a moment's time. So far, the regulator has been silent on climate change, and I think it's becoming more and more untenable. Why do I think that? I mean, one line of argument would be, what's climate change? Like, do you know what it is? Do you know how awful it is? Do you know what's going to happen? That line doesn't take us very far with the regulator or with large law firms. What's better is, the regulator has spoken very actively on some other things. So if we have a regulator that simply said, here are the principles, they apply to all sorts of lawyering, and we'll give you some guidance generically, but it's not our job to say, oh, for climate harms, here's some special guidance. I might be okay with that. But that's not what they do. Over the last few years in particular, they have issued particular guidance on particular issues. So one is on non-disclosure agreements in employment law, and another is on SLAPs, so strategic litigation against public participation. What I keep on saying to the regulator is, if you felt it was so important for you to speak publicly about NDAs or SLAPs, why are you not saying anything about climate change? Also, the Law Society, which is the trade union, the representative body, they have said something about solicitors and climate change, which is kind of, to my kind of quick read, broadly comparable, although also different to what I see the Law Council of Australia did. The Law Society is a messed up institution. It is full of politics. It represents the solicitor in a kind of single high street practice to the largest law firm. And yet somehow, with all that politics, all of that history, that lack of identity, everything else, they still manage to get this public guidance out there. And it's pretty strong. You know, it kind of says, well, it's pretty strong for lawyers. It says the climate crisis is real. It says think about the climate crisis. It says those principles exist, they're legal requirements. These things impact on what you're doing in practice broadly. Interestingly, the Bar Council, which is the trade union for barristers, is this close to publishing something very similar that I've been kind of helping them with. And what's interesting for me, and given the conversation we had earlier, part of the thing for the barristers is, if you're in court and asked by your client to advance evidence that you think is not sound in relation to the climate crisis, what should you do about that? And that's causing a big sting. That's kind of bigger than this. But going back to the regulator, they've said stuff on NDAs, they've said stuff on SLAPs. The representative body has said something, they are still silent. I think it's becoming more and more untenable. I mentioned that I'm going to do some work over the next 12 months on tort. And what's interesting for me is what the Law Society guidance, so it's soft law, we're only a representative body, there's no obligation to follow it. What does that guidance do to the obligations in tort? And what I'm interested in, and maybe it's different here, but what's likely to happen at home is if a large enough number of solicitors act as if the Law Society guidance was not guidance, as if it was law, as if it was a requirement, that then means that practice across a chunk of the profession has shifted, which could mean, depending on the body of case law that you follow, that the duty of care has also been changed and or the standard for measuring breach has also changed. The joy of tort at home, guessing not that different here, the cases are a mess. Like they're just a real joy to get into because they're so kind of conflicting. Interestingly, this is the thing that the large law firms care about. So they're not so bothered when I go in and say, the principles, which are law, mean that you have to do A, B, and C. Instead of I go in and say, oh, like, you might be negligent, and your insurers will care if you're negligent. That's what gets them bothered. So this is my kind of project next 12 months or so. So they're the rules. I think the rules require some active counselling on environmental issues, possibly when we get engaged in public interest to walk away, although we know those rules don't have that much purchase. What else? Well, the rules are simply the beginning. You know, as professionals, we expect more of solicitors and other types of lawyers. We expect a certain type of behavior from them because they are professionals using their expertise in the public interest. So we're getting into the realm of lawyers' ethics. And what I love, and it's kind of, I use this almost every time I talk about lawyers, is this quote from the Regulatory Tribunal, the SDT. So the SDT is not known for saying anything interesting or indeed controversial, and yet this is what they said. A solicitor must and should on occasion be prepared to say to his client, what you seek to do may be legal, but I'm not prepared to help you do it. And this is kind of a really useful kind of hook for me when I'm talking to practicing lawyers, because what they will say is, well, we think we're compliant with our regulatory requirements from the SRA. Isn't that the end of the story? And I say, no, that's not the end of the story. Like, you need to think beyond that. There are good, compelling reasons why. And actually, in a different piece of work at the moment for a different regulator, we're doing a big report on lawyers and the rule of law. And what we found actually was some really helpful dicta from judges in the last 10 years, basically repeating this, but in the Court of Appeal and the High Court. Basically saying to solicitors, your independence and integrity mean that we expect more from you. We're not going to say what it is, but we expect more. And that should come out later on in the year. So thinking about lawyers' ethics now, what does it mean to be ethical beyond the baseline of the rules? Standard conception will be familiar to many of you, so I'm not going to teach how to suck eggs. Various competing theories of what it means to be ethical, how we judge kind of ethical conduct. The most dominant, with a bit of a resurgence, the standard conception says that we don't associate lawyers with their clients, we don't hold lawyers accountable for what their clients do. Lawyers have the duty of partnership, lawyers will do what their client needs them to do. And the kind of various bases for that standard conception, lawyers and clients aren't separate, lawyers get to do whatever they like for their clients, the limits of the law, partly that we live in these competing plural societies, we disagree on things, partly that the law is the law and you have to have fidelity to it. Sometimes a respect for client autonomy, they would do these things for themselves, but they can't, and so on and so forth. I have a bit of an issue with the standard conception generally, but in particular in relation to the sorts of things we're talking about today. So that body of the standard conception, that body of arguments, is sometimes what gets thrown back at you for why lawyers think it's okay to damage the environment. You know, I didn't make the rules, I didn't set them. If it's legal, it's absolutely fine. I'm just helping my client, they need my legal advice, those sorts of arguments. These are all pretty basic, but I've run through them. Nothing particularly new here from me. But the standard conception largely comes from a kind of criminal context. Those sorts of arguments, I need to help my client, I need to kind of defend them, I need to kind of support them, makes much more sense in a criminal context where the kind of consequences are so dire and where the person on the other side is the state. That's different. Like if I'm helping my client finance an oil field, like why are those arguments the same in that situation? Equally, respecting an individual's autonomy, it's not necessarily true that the same respect should map over for corporates. Like it might do, but it's not necessarily the same. Liz Fisher, those who aren't environmental lawyers, I should take a step back. Environmental lawyers love to think that I say this as an environmental lawyer, lots of love and respect. Environmental lawyers love to think that they're special. And so a lot of scholarship in environmental law is special pleading, or it is in the UK, maybe it's not so much. Over here, environmental law is different. And so Liz Fisher says, well, one of the things about environmental law is it's hot. It's kind of complex, it's polycentric, it's a mix of politics, economics, and social issues, constantly changing, there's a dynamism, etc. Now, I think some of that's right. The reason why I mention it here is, if the argument from a practicing lawyer or anybody else is, well, if it's legal, it's absolutely fine, the presumption behind that is that it's really simple to know what the law is and what the law means and how the law gets applied. In the environmental context, a lot of environmental law decisions, a lot of environmental law scholarship is about the fact that it's not so simple, not so set, not so obvious, is really hot, is really difficult. And then the final point here is that when we're thinking about the standard conception in the kind of criminal context or other contexts, what we're saying is this individual's liberty really matters. That's why the lawyers should do whatever they can to support them. The environmental movement, a lot of it is often about collective needs, and actually sometimes the need of the collective having to outweigh the need of the individual. The other thing that I'm starting this year, which is kind of difficult for me because it's not my usual thing, is to kind of learn more about climate justice and environmental justice. So Rob Atkinson talks about the justice that underpins the standard conception as being a very small, very limited form of justice. And yet we've had decades of work since the Warren County issues in the US on the siting of landfills, which tell us that when we're thinking about justice in the environmental and climate context, we need to think much more broadly. We need to think about distributive and substantive impacts as well as procedural. We want to think about intergenerational justice, ecological justice, etc. And I don't think that very much has been done so far on what those climate and environmental forms of justice tell us about the form of justice that underpins most of lawyers' ethics. Like, what would that work tell us? Well, tell us it's wrong, I think very short paper, but in what ways is it wrong? In what ways is that form of justice in the standard conception limited? And this is kind of something over the next year or two. A couple of points that I shall wrap up. This seems obvious to me as well, but I think less obvious to some people. Maybe I'm wrong. My feeling is that a lot of the conversation about lawyers' ethics is about what lawyers do when acting for clients. So you're acting for a client, is X or Y okay or not okay? But the very largest law firms who are doing the financing of the oil field and new kind of licensing rounds, I'm not convinced that their initial decision to take on the client is a lawyer's ethics decision. I think it's just a business decision. I think it's a question of expertise and capacity, it's a question of profit. It might be about the individual moral preferences of the individual partners, but I'm just not so sure that that is a lawyer's ethics question at that point in time. Once they start acting, and a lawyer's ethics gets engaged, but I'm not so sure. And almost everybody who writes about lawyer's ethics who's in favor of the standard conception accepts that one of the bits of agency you have as a lawyer is to not take the client on in the first place. And David Wilkins, which I think, I really like that phrase, deciding which clients you take on has a moral significance. So I think these are generally business decisions. What will also shape those decisions more and more these days are these things on the screen. So yes, profit and reputation, but also law firms want to be seen to be green. I think we're going to hear shortly about the work of law students for climate accountability. Law firms are bothered about who comes into the firm, about the students and the lateral hires. They're also increasingly more bothered about client views. So I know one very large law firm that is this close to publicly saying it will not take on any new matters for their carbon major client. And the reason, I'd love to say it's because they really care about the environment, I'm sure they do, but it's because a gang of other clients who are worth a lot of money to the law firm, more than the carbon major client, have come to this firm and said, we are really unhappy you still do this work. And that is kind of shaping their decision making. And more broadly, this kind of idea of sort of ESG regulation. It's a bit different for barristers, and I say a bit different. Cab rank, this idea that, like a London taxi, if it's got its yellow taxi light on, the taxi should take you wherever you want to go. The taxi doesn't get to say to you, I'm not going to take you. If the taxi is available, it takes you. That is the cab rank rule and where it comes from. There's some interesting work which kind of suggests that's not always the case, that the cab rank doesn't always operate in that way for barristers, and the same is true for taxis. So if you're in the middle of Soho, you want to go south of the river at 3 a.m. on a Sunday morning, a taxi will find a reason not to take you south of the river at 3 a.m. on a Sunday morning, and that happens with barristers as well. The clerk says, I'm really sorry, they're just not available. Or the clerk says, oh, really, well, their conflict's out, or they're on holiday, or there are other reasons why it can't quite work. Barristers are really touchy about this. I'm not sure if I'm guessing it's the same with barristers, the same all over the world. It's the same, it's just, they're so touchy about this. And what they do is they just shout cab rank at you. So you say, can we begin a cab rank? I'd like to have a conversation, cab rank. Could we please talk about cab rank? And it's really disappointing because it makes them look as if they are deeply ashamed of what they're doing, and this is the only thing that they can do to kind of push back against it. It's kind of, at least with the solicitors, they have more of a debate. The barristers just aren't willing to do it, or at least they're not at home and not in the same sorts of way. So because I think, and again, happy to be told I'm wrong, that for the very large law firms, taking on these carbon major clients is a business decision, I think it's perfectly reasonable to say to them, well, why did you make that business decision? Why was it that you thought BP needed your help with this new licensing round? Why was that? Like, tell me. And what they then say to you is, well, everyone deserves legal advice. By itself, I don't find that very convincing. I don't find it very satisfactory. I don't find it very sufficient. And it's not because I want to shame these lawyers. It's not because I think they are bad people as people. It's because I would genuinely like to know, like, what is it that made you take on this client? If you say it's profit, I'm going to disagree with you. I think it's not a good reason, but I'd like you to just be honest about the reasons. Like, what is it that's actually going on? And what I find interesting, so I do a lot of this work inside law firms, just with partners, because they're afraid if the associates hear what's going on, they'll all revolt. And what you realize is, like in any sort of large group, the partners just all disagree with each other. Some are really pro, let's be very public about this stance or that stance. Some are very anti. And sometimes it's about the clients they have, and sometimes it isn't. But I think just saying everyone deserves legal advice really isn't sufficient. Part of this kind of is linked to the work I've been doing on the rule of law, and about what access justice kind of means. I don't think anyone feels the rule of law means that any given client has the right to a particular lawyer or a particular law firm. You don't get to say, I get to have Herbert Smith Freehills, to give an example, or Slaughter May. I'm not entirely sure what the rule of law really means that there is a right to a lawyer in civil cases. That kind of is more complex. As Christine and others have written, we know that power distorts access to justice. I did a piece of work once looking at the top 100 law firms in the UK and what their pro bono looked like. And their pro bono was largely reading in schools and painting. It was not free legal advice. You would think if these large law firms genuinely cared about access to justice, they would do something that helps support access to justice when they just don't. It just doesn't happen. And the rule of law, kind of more broadly, as an argument, I think is unpersuasive. I think it's unpersuasive because when the people I hear in the large law firms say, the rule of law requires, or permits, depending on who it is, that I act for this very large carbon major client, what they're really saying is, it's legal, so that's the end of the story. That is kind of what they're often saying. And it sort of comes as a shock to them when I say, there is no agreement on what the rule of law means. We have this deeply divided debate between formal and substantive conceptions. The regulators, the 9 regulators in the UK, all have different views on what rule of law means. Judges, the law officers for the government, we all disagree about this. And only in the very thinnest of thin accounts that hardly anybody believes to be true is the line, because it's legal, is the end of the story valid? So if you're going to use this, a bit like everyone deserves legal advice, let's have a conversation about it. I'm very happy to kind of summarize all the work for you on what's happened on rule of law and what it means in practice. The other thing I think is that I wouldn't be disappointed if a lot of large law firms got together, putting to one side competition and antitrust issues, and collectively decided not to act for the carbon majors. Like, do we really think that's a rule of law issue? So individually, any law firm saying, this law firm, my firm, we will not act, that is not a rule of law issue. A single law firm saying that is not. Is it more a rule of law issue if a whole group of law firms get together and say, we will not act? I'm not so sure it is. I'm not so sure it is. So the rule of law is about kind of knowledge about the law. It's about enforcement of rights. We think that these multi-billion corporations, larger than many states, wouldn't be able to know the law or enforce their rights if they didn't have representation. Do we think they would be treated really unfairly in the courts if they came as corporate litigants in person? If we did think that, why are we more bothered about actual litigants in person? I know this is controversial, it's kind of why I'm ending on this. This is kind of the current piece of work that I'm doing. But I am really struggling with this. I'll leave you with that struggle. Thank you.
Thanks, Stephen. That was marvelous. Lots of questions, lots of things to agree or disagree with, I think, even if we all roughly agree. I think what we might do is we might get the others to talk about what they're doing in law schools in Australia, and then we'll have time for more discussion and so on. So first I've got Vivian Holmes, Susan Barty and Emily Brow, who are working on bringing the Law Students Climate Accountability Scorecard to Australia. And they're going to come and tell us what that means. You have to come up the front because we've actually got 13 people on Zoom, so they want to be able to hear you, I'm sure.
Well, maybe I'll start off and just give a bit of background to how this came to be. And it was partly thanks to our friend and colleague Adrian Evans, who told me that AN used the law school to take on this project for various reasons. So after a while, I got into contact with the executive officer at the Law Students for Climate Accountability in the US, which started at Yale Law School, but is now a not-for-profit in the US, and said, we want to start up a project like that in Australia. Do we have your blessing? And she said, yes, go for it. And then I was at interestingly, at an International Women's Day breakfast, and very serendipitously, didn't know Em, but ran into her and said, I want to get this project going. She said, great, I've just come back from the RBA in London where I was working on climate, and I'm really interested. And that's where it all started. And I got Susan on board. Do you want to say a few words? And then we'll pass it to Emily, who's really doing all the work on it. So
Sure. Yeah, that was my first day at ANU, and Viv, I think I was still trying to work out what my password was, and Viv came into my office saying, oh, do you want to join in this new initiative, which sounded fabulous. So I think Em will take us through the detail of it, but essentially it is an initiative designed to create greater transparency when it comes to law firms, trying to actually get a sense of who they're acting for and what kind of transactions and litigious work they're doing. It's different from the American model in the sense that the Americans also look at lobbying, which is something, as far as we know, doesn't really happen in Australia. So I think that's the main point of distinction between the two initiatives.
as in it doesn't happen from lawyers.
Doesn't happen from lawyers, so
Yeah.
yes, thanks for the qualification. So that's a major difference. Em, did you want to talk through the specifics of what you're looking at? Yeah.
I think that people probably want to know what it actually is.
No, so as Viv had mentioned, we could get into a conversation at the International Women's Day breakfast about deceptive marketing on the part of law firms. And I, very luckily at that time, had just finished up working at Minter Ellison, where I'd worked for 3 years. And they have a whole office dedicated to mining. So, I mean, I personally would go home most of the days that I worked, and I didn't fully recognize this until after I left, but I would just feel really, really morally torn about the work that I was doing. And I think that sort of went into doing a lot of extracurricular and volunteering to try and balance it out myself. But when I was at the IBA, I did a lot of work in the run up to COP27, and they were running an event with a few different bar associations on the role of lawyers in addressing climate change. And one bit of research that I did was on what law firms and law societies were saying and doing about climate change. And very quickly you realize it's all, sorry for my language, but bullshit. It is constant references to their, you know, ESG podcasts, their paperless offices, how they're part of the Lawyer Net Zero Alliance, where they have, you know, they're carbon neutral by 2030 on their office emissions. Nothing to do with the actual work that they're taking on. And so then when Viv had mentioned the work of Law Students for Climate Accountability to me, I hadn't really heard of their work before, but it really, I looked a bit more into their work, and they've done some really, really amazing work. So the US, they looked at 3 different areas. So litigation work, lobbying work, and transactional legal work. And for that, they focused on the Vault 100 law firms, which are the top 100 US law firms. And so when we were sort of thinking about starting this, obviously the Australian jurisdiction is very different. And in talking to the US a lot, I wasn't necessarily content with their process for research. So sort of have worked over the past couple of months to figure out what the best way to sort of get to the same end product as the US is in the Australian jurisdiction. So we started it up with just ANU, Monash, and University of Sydney, but we've got a few more universities on board since then, which is really, really great, because obviously it's Law Students for Climate Accountability, and it's not just law students from these particular universities for climate accountability. But so what we are doing is, obviously, as Susan mentioned, we're just looking at litigation and transactions. So for litigation, the University of Melbourne has a very wonderful Pacific and Australia climate change litigation database. So we are using that database as well as Climate Case Chart, which is what the US used. And then we are also going outside of the databases. So we are currently at the moment doing reports into a bunch of different fossil fuel and renewable energy companies, because really want to make sure that we justify including the work of particular companies within the scorecard. So for that, we'll then go out and record the litigation which firms have done for those fossil fuel companies, which may not be captured by the methodology of the database. And then for transactions, the US, they used one project infrastructure database called IJ Global, and they have very kindly shared that data with us for Australia. However, in looking at that data, I realized there were a lot of different transactions which were missing, and I just wanted to make sure that we were as comprehensive as we could be. So I did a lot of research into the different resources which all the universities have for finance and actuarial studies and commerce, which is not my area, but been very interesting learning all about these new databases, but have found a fair few different really amazing resources which provide a lot of different data about all of the transactions that go on. And then once we have all those data sources with the company reports, you have the major projects listed, and you know that there are, within every single big transaction, there are particular transactions which occur, which law firms always facilitate. And there is no data you cannot find without with enough rabbit hole researching, because firms do love to talk about the work that they do. But yeah, so we will then, with all of that data, we're looking at 10 years, but we will probably shorten it to 5 years for the purposes of the actual scorecard. But yeah, so then you, using all of that data, you then give each firm a score from A to F based on the amount of work they've done for the fossil fuel industry. So in that space, renewable energy work and pro bono work, although we record it, it doesn't offset the score for work done for fossil fuel companies, because I mean, I don't think that argument's that ridiculous, but it's, you know, you can't really offset the emissions of, you know, facilitating a coal mine opening with some, you know, helping a solar farm get set up. Although it is great work that they are doing, but however, that work, which they love to highlight, is one of the issues, and it is they are constantly trying to draw the focus away from the actual work that they're doing. And yeah, so sorry.
I just wanted to point out, because we've been talking about this for so long that sometimes we don't point out the obvious, but the purposes of the scorecard is really twofold. One is to educate law graduates so that they're very informed about the type of work their potential employer is doing. So in other words, raise with them, well, do you want to spend your life's energies helping destroy the world in, so maybe they may not, that might, in the US, I think the experience has been that that might decide a student rather than go with a firm scored F, they might go with one scored C. So there's that discussion. And then there's also trying to create the discussion within the profession, which is really what Stephen and others are doing, which is, you know, what's the profession's role in this, and can we give it some really serious consideration because of the crisis that we're in. Yeah, so that's what the scorecard is that's the purpose of it.
Thanks. Okay, I'm going to get you guys to sit down again.
Otherwise, we could mention the declaration.
Oh, yes, yes.
Very quickly. Sorry, I was just going to quickly mention, because may ask for someone for your signatures after, but there has been some really amazing work being done in the UK this year in relation to the role of lawyers in addressing climate change. And one of the things that has been done is there was a declaration published by a group of UK lawyers and other legal professionals, which said, among other things, that they will not provide their professional services to new fossil fuel projects or to aid in action, be it civil or criminal, against peaceful climate protesters. So it was signed by 120 legal professionals at the time it was released, including 12 KCs, and that it brings up a lot of issues with the CAB rank rule, and I've had much experience with that being the default response on email from many legal professionals. But I do have a working group together of different legal professionals working on adapting the declaration to Australia. So you should all sign it once it's once the draft is finished.
Yes. Great. Well done. Thank you. All right. And Adrian, are you going to tell us about real?
Okay, so at Monash we have a climate justice clinic, and its purpose is to infiltrate the legal profession on a long-term basis. Essentially subvert as much as possible the current cab rank attitude. So we're trying to look to the future rather than really create major change in current lawyers. And I think the best way to do that is to put law students in touch with clients who are suffering from climate change and who are not just thinking about the possibility that they might be flooded in the future or something like that. So we've done a number of jobs, research jobs and also advocacy jobs for clients who are on that edge. A group of East Gippsland farmers who were burnt out 3 or 4 years ago, and who suddenly realised they don't actually know how to deal with the government when it comes to management of the land that they thought they were in charge of, and they're not, due to all the overlays that apply to forest lands. We've done work for a major NGO that is concerned about the capacity of its membership to protest without being prosecuted. And as you know, the degree of protest around the world is growing every day. And certain companies, particularly Woodside, have realised they can weaponise that and are going to increasingly do that. So a database of the various protest rules around the Commonwealth that apply to this situation has been another project that the students have worked on. What's made the difference for them is actually talking to people who are in the firing line. All students aren't typically known to be in the firing line, but I think due to Emily and Susan and Vivian's work, they're learning about that firing line at that level, but they're also learning about it when they're dealing with people who are suffering. And I think that will be transforming it over the medium term. So that's enough for me.
Adrian, speaking of Liz, who do get in the firing line, Julia Tam from La Trobe Law School.
Thank you.
That was a good segue.
So I briefly want to talk to you about a project that we're doing about mainstreaming climate change in legal education. There was a terrific special issue in the Queensland Year Law Review at the beginning of last year that made a really compelling case about why we need to be doing this. But I think where the gap is about having resources that make it easy for our overworked colleagues to actually do this work. So as part of this project, what we're trying to do is create resources to assist in mainstreaming climate change in the legal education. And I'm really excited we're now doing an open access textbook together with La Trobe e-Bureau, which publishes open access textbooks. So it'll be easily available, free for students to access and completely electronic, which allows you to do a lot of different things with it. And it keeps expanding. So we've now got 17 chapters, so including a chapter on almost all of the Priestley 11, so the compulsory core subjects that students have to do as part of their legal education, as well as some popular electives. And I'm thrilled that there's 3 chapter authors in this room. Vivian's writing a chapter on professional responsibilities, Brad on clinical legal education, and Christine on consumer law.
And Julian's co-authoring.
Oh, and Julian's co-authoring. Fantastic. And so the idea will be to publish the first tranche of chapters by mid next year, so it could hopefully be used in second semester teaching, and the second tranche of chapters in for semester 1 the following year. And again, the electronic format will mean that it's easy to update because we know there's so much change in development in the law in this area. So I'm really excited about that part of the project. And the other part of the project is to map what's currently happening. So we've got ethics approval. We're hopefully going to send out a survey to all Australian law academics in the next week or so to find out to what extent people are already incorporating climate change in their teaching of particular subjects, and if so, how they're doing it. And again, that information can potentially feed into, what we're doing in the textbook as well. And then also to find out what are the key barriers that they're experiencing, whether that's time, knowledge, resources, etc., so that we can then develop targeted interventions to really support that. And then the final part of the project is really trying to build a community of practice of legal academics who are passionate about mainstreaming climate change, to share resources, to share ideas, and to sort of promote the need for this and strategies about how this can be done at various Australian law academic conferences, etc. So, yeah, thanks.
That's great. All right. Stephen, you're going to come back up for questions, but I'm also going to, because we're going to have discussion and somebody's got to be in the hot seat. Somebody's got to be in the hot seat.
Turn on, ask the questions.
But did anybody else want to share anything else? So sort of my idea was, I don't know if this is working or not, but my idea was that he sort of gave that talk about, hey, we should all be doing something. And then people sort of go, hey, we're doing this and we're doing that. Is there anything else that we don't know about that's kind of in that? Emily's got another one. What?
No, it's just as part of the project, you would have all heard of Anjali Sharma. She's a first-year law student at ANU this year. She was helping with the project, but she has been working with Senator Pocock on the duty of care bill. And so helping at the moment with campaign staff for that to try and build signatures on the petition. And you should all sign it and get around the campaign. Oh yeah, so the bill which has been introduced, it places a duty of care on politicians in their decision making and policy making to account for climate interests, and it's an intergenerational justice. So it's for future generations of future climate harm. They have a duty of care. And I'm not sure at the moment if it'll get up, but it's a very, very great initiative.
Yes, and Anjali Sharma was a litigant who tried to get that via the courts.
Christine, she wasn't the litigant.
No, she was
The Nan was the litigant.
Oh, that's true, because she was too young.
Correct.
Yes. Okay, I'm gonna give this back to you
Thanks.
because people might have comments or questions for you, Stephen, or for each other. This is meant to be a round table discussion. Vivian,
Thanks, Stephen, for your talk. Really interesting.
speak up.
Sure.
Where
Thanks.
those green lights are, there are microphones.
Oh, okay.
So direct your voice towards those.
Right. Thank you so much for your talk. Really interesting and informative. I'm wondering in your discussions with large law firms, because it strikes me I hope there are parallels with the campaign against big tobacco and how that became socially unacceptable to work for them, for many people, clearly not all people. But I'm wondering whether in your discussions with large law firms that comes up, and actually, do you know who does keep working for big tobacco and how they're considered?
So I can tell you a very personal story and then broaden it out. So I work for BP and BAE Systems. And when I joined the department at Freshfields, they also worked for Japan Tobacco. It was their third biggest client. And my mum had died when I was very young from lung cancer, from smoking. So I joined the firm and said, at the department, I said, I will do anything else you want, but I won't do tobacco. That's the thing that I won't do. And at the time, they were like, totally fine, just do this work, don't do that work. And then after a while, they said, oh, it would be helpful if you do a little bit of tobacco. And I was like, no, I'm not doing tobacco. And eventually it became too much and I decided to leave. And I talk about this a lot in my writing because I think when you talk to practicing lawyers who say everyone deserves legal advice, and I say, well, would you act with this sort of client or that sort of client? They often have their own personal red lines. I call this meatloaf lawyering now. I do anything for my clients, but I won't do that. They all have their particular groups. And tobacco is interesting because there are still some London firms like Freshfields who are very happy to do it. The other reason it's interesting, I'm not looking at anyone in particular in the room, when Herbert Smiths and Freehills were merging, the single biggest sticking point was not about the finances, how partner profits would be divided, it was tobacco work. And in London, Herbert Smith said, the partner said, we do not do tobacco. We are not a tobacco law firm. But the profits from the tobacco work from Freehills were just so significant that actually that became the thing that swayed the partners' minds. And what's interesting is some of the other law firms in London are like, we would never do that. And you just don't know because they never had that opportunity, it's never kind of come to them like that. So yeah, when you talk to the partners, the things that often come up are gambling, arms, tobacco, and pornography as things they wouldn't do. Very rarely climate change or climate harms. Those other four, we're not the sort of firm that does gambling or pornography, but we'll do climate, we'll do climate. So there is a bit of a conversation around it, but not so much. Does that answer everything?
Yeah, it does. Yeah.
Emily, yeah.
I was just wondering, when you were talking a little bit about, for example, the guidance, I read a paper the other day about how it may become a regulatory issue for lawyers if they're not advising on particular climate risks, and therefore they may accrue liability through failing to advise the client. What's your sort of thoughts on that and how that might actually, whether that might actually be a reality?
Yeah, it's interesting. So one of the visiting professors at UCL, Sarah DeGay, was former general counsel of Slaughter and May, one of the Magic Circle law firms. And now that she's stepped away from Slaughter and May, sort of nudging her in a different direction. And she's written a paper partly on that, that's online and free to access. And she, because she's a former general counsel of a Magic Circle law firm, doesn't quite say this, but she's getting close to saying, actually there is now just an obligation to advise, like how would you not advise? And so hearing about your climate conscious book is fantastic, because what a lot of lawyers will say to you is, but I just don't really know how climate change impacts on my particular practice area. So I'm an employment lawyer, I just don't know if it's relevant or not. Therefore, for my duty of care, how am I acting competently? If I don't, like, I know climate change exists, like fine, but I don't know what it means for employment law. And what the Law Society guidance tried to do in about 2 paragraphs for each big subject area was say, if you're an employment lawyer, think about this, which is why I'm kind of so pleased to hear about this project, and also disappointed that we're not doing it yet. Well, we're not thinking about it yet ourselves. So yeah, and that's got to be right. The other thing that I find really fascinating for us is that idea, the regulatory requirement, acting in the client's best interests. There's no guidance on that from the regulator. There's no case law on that. You know, we kind of have a guess at what it might mean, but nobody knows. But if there's just such a volume of environmental, social, and governance regulation, everyone just knows it's everywhere. Everyone knows it's a thing. How can you then say, well, I have an obligation to talk about this with my client if it is just everywhere? It's kind of, they're 2 hard things to put together, even if you as your employment lawyer don't know exactly what it means for your particular practice.
Sorry, I don't know your name.
Hello, I'm Grace. I studied at ANU and I'm an environmental lawyer at the Environmental Defenders Office. So my practice area is in coal and human rights, and we run litigation jurisdictionally trying to challenge new fossil fuel projects. I just wanted to touch on what your comments were around pro bono practices in law firms. Interestingly, I had a discussion with Earth Justice because we're undergoing a restructure as an org at the moment. And we've looked to the way that they have challenged new power stations funded through Bloomberg, using a lot of private law practitioners to help with some of the day-to-day resourcing to achieve that. And I think, like, nationally, Australia's focus needs to be stopping new coal and gas projects. Obviously, it's said by the International Energy Agency in 2021, yet we're still improving coal mines every month. So there seems to be there's a lack of, I think, in America, the perception of a public interest lawyer is very sexy in the environmental space, and there's lots of demand for it, and it's well regarded. And in Australia, unfortunately, I don't think there's as much emphasis or weight put on that as an option for a law student, and there's no grad program, for example, at the Environmental Defenders Office. So there's an expectation that you get your foot in the door at a commercial law firm, you develop skills, and then you transition into the CLC sector.
Yeah.
But by that point, it might not be financially viable, whatever, there's other factors at play. But I think if we can have, we can turn our minds to how we can encourage private law practitioners at big firms to take on pro bono clients such as the EDO, subject to conflict interests and things, then it allows practitioners to work together, and then we can work towards achieving, this ultimate goal of meeting our Paris agreements and getting to our 2030 net goal. So there's, I hope that it can be a discussion that we can have, as lawyers, and trying to achieve that more collaboratively, which it seemed like it worked for Earth Justice in America. And there's definitely, I think, viable options. It's just more about how we can get there together.
No, very much agree.
More of a statement than a question.
Sorry, no, I was saying I was agreeing with you. I'm sorry, I didn't mean to speak over you. I very much agree. I'm often a bit of a pessimist, sadly. And what I saw in my own time in practice and what I see now is law firms have a choice really of how they frame a conflict of interest when it comes to that sort of work. So there'll be kind of rules on what a conflict of interest actually is. And then clients, through panel engagements or through terms of reference or just through conversation, will broaden the ambit of what a conflict of interest is. So it might be, for example, that my law firm does work for BP. And so an obvious conflict is you bring a case from the opposite side to BP. The much broader framing, more common framing, is any piece of work in which BP might have an interest anywhere in the world. That is much more common as a conflict framing. I don't know whether it's the same over here, but that's much more common, which means that it just knocks out so many of the possibilities. And I think what's starting to happen, I see these 2 law firms at home, and one was very public, DLA Piper, they're very big on it, is trying to bring more of that work back in-house. Now, they're doing it for a number of reasons. One is they say they care about the environment. 2 is that some of their lawyers were leaving them, they didn't like that. And 3 is they want to keep their lawyers happy. One of the reasons I have a job is that at home, law is an undergraduate degree. On the masters, we have a specialist master's in environmental law. Almost all of my students are lawyers in their 30s and 40s having midlife crises, who've been banking lawyers, litigation lawyers, and derivatives, whatever they've been, who want to then go and work for somebody else. And I think that's happened relatively recently, the last 10 years with us, is Client Earth has become a ginormous employer of very successful environmental lawyers. So they know that you have to have some environmental law expertise. And so there's a lot of kind of retooling that's happening. But the conflicts thing, I think it's really disappointing because I think it takes the firm to say, actually, we're gonna frame conflicts in a legal way, but a much more narrow way than our clients might want us to.
And the EDO or like other public interest law firms need to manage, like we manage conflict as well. We just have certain privacy laws or whatever, because some of our practitioners have, you know, had the inverse type of conflict where they've represented certain clients and then they come across. So it's definitely manageable if there is a will, there's a way, but yes.
I mean, I personally think that that broad framing of conflicts is completely unnecessary and defeats the whole purpose. But at the same time, I'd be very careful about those screens and so on. They may not actually end up working at the end of the day, as we know from the case law. David, you had a question.
Of course, I have a question. I should say I'm David Crowley and I am definitely not a lawyer. So my question will be based on my lack of knowledge of the law.
You probably spent more time in court than some of us.
No, I doubt that I have. But the question is really, I mean, you focused on law quite sensibly, but how much climate knowledge, particularly climate science knowledge, would you expect environmental lawyers to have to work on climate law rather than law knowledge? Because a big issue with some grey-haired older men who are magistrates or judges is their erroneous or potentially erroneous judgments, decisions, based on their lack of knowledge of climate science. And in particular, for both trainee law students working on climate law, how much climate science knowledge should they have and how much law knowledge should they have?
Yeah, really good question. Annoyingly, perhaps I'm going to answer it as a lawyer. So states of knowledge tend to be ex post facto. As in, at some point in the future, a decision maker will say, your knowledge at this point in the time, 5 years ago, 10 years ago, should have been this. And either it was or wasn't that state of knowledge. That's really unhelpful because it doesn't tell you, like, what do the practicing lawyers today need to know? So I think 2 things. One is that for environmental lawyers, those who kind of say, I'm an environmental lawyer, I work in an environmental team, we would necessarily expect a higher amount of knowledge than we would for the employment lawyer who doesn't know anything. But equally, it can't be zero knowledge for the employment lawyer because their starting point has got to be, from society that this is such an existential issue, it's such an important issue that it would be negligent of them not to acquire a baseline. Then the question becomes, what does that baseline look like? And that's what always gets thrown back at you by the practicing lawyers. What does a baseline look like? And it's one of the things the barristers are really struggling with. So there's one group of barristers who are saying, well, like, what is it enough for me to know? Like, how would I, so a client comes to me and they're on the other side in a climate dispute, and they want to advance some body of knowledge which says X. Am I meant to go and read the IPCC reports? Am I meant to go and read the executive summary for policymakers? Am I meant to go and do blah? And what I remember is that when I was in practice, most of my practice early on was about contaminated land. Like that was kind of, can you build on this piece of land? Is it contaminated? Now, I didn't really know anything about that. And then later on, my practice was about chemicals and chemical regulation. And I knew nothing about chemicals, but I knew enough to know when I had to go and ask an expert. So I knew enough when I had to go and say to my client, we need some of your resources so I can ask this person this question. The legal question is this. I need to be able to know, is it A or B? I need to borrow your expertise. I think that's probably sort of where we are. Although I think there must just be a baseline. I've done that lawyer's thing of going around in circles and not giving you a great answer. I don't know, like, what would we say? Would we say, we expect all practicing lawyers, actually, I do know an answer. In the England and Wales, continuing competence has moved to a system away from you do 12 hours of study a year to you need to reflect on what it means for you to be competent and take active steps to make yourself competent. So what I would expect given that and this is that any practicing solicitor should say, okay, I'm an employment lawyer. I've heard of climate change. I don't know very much about it. I'm going to do some research and try and understand at a very kind of generic level what it is. Do some thinking about what does that look like for employment law. Now, I might not get it right. I might miss all the nuance. I might not understand some of the modeling, I might kind of misunderstand how it applies to my practice. But what I should be able to do if I was a regulator is to walk into that office at the end of the year and say, what steps did you take to educate yourself? I'm not going to set a benchmark because actually I don't think that's really helpful, but I want to know the steps that you took. That's actually what continuing competence means. So that wasn't an answer in the way that you wanted it, but it was, I hope, an answer.
All right,
I have a question.
I have a question on the board as well. Oh, thanks.
It's an easy question.
Okay, hang on, I'll do that one first, give the people, the Zoomers a chance. What is your, oh yeah, very easy. What is your view on whether and how lawyers should engage in non-violent civil disobedience relating to climate change?
So in the report we've just written for the Legal Services Board, which is the overarching regulator of all lawyers, there's a paragraph that I kind of added in that Richard Moorhead, my co-author, I think didn't read, which was about this, where I said, the rule of law means lots of different things. At the most substantive end of the rule of law is this idea that laws need to have a sense of equality and fairness that is substantive in addition to all the procedural stuff. Are laws clear? Can you go to court? Will your rights be enforced? If you really believed in that very substantive version of the rule of law, you would also have, I think, very strong views on the worthiness of particular laws. That's not the case at this other end of conceptions about the rule of law. I think it's perfectly legitimate for a lawyer to say, I have very strong views on the substantive framing of the rule of law, which means X, Y, and Z. I also have very strong views on the worthiness of laws, and therefore I'm going to engage in non-violent civil disobedience. Whether that then means you're not up for regulatory consequences is a different thing. Because often just saying the rule of law is not a defense when a regulator says, I think you've also kind of broken some other of your professional obligations. It's sort of easier when it's non-violent civil disobedience because at least, well, for the moment in my country, that is legal. We're getting to a place where it's not. It would be different if it's violent disobedience. So Lawyers for Extinction Rebellion, I talked to them a fair chunk. Emily mentioned the declaration by Paul Housel and Tim Crossland. Part of that conversation is about, and when do we cross the line? But we know, don't we, from kind of work people in the room and others, that actually lawyers are often active agents for, or can be. They can be instruments of justice, they can be instruments of change. At what point do we, as a community of, an epistemic community of people doing this sort of work, feel that something very positive is needed? What do you think, Christine?
I think.
Well, it's a very hard question. I was kind of curious.
Well, I'm just going to go to somebody else.
Okay.
But I think at one point in my teaching of lawyers ethics, I did look very hard for examples of lawyers like non-violent civil disobedience, and there are not that many examples actually that are recorded in the books, but there are a few, like Gandhi was a lawyer, for example, and so on. But I agree with you. I think sometimes lawyers have to be disobedient to demonstrate what's wrong with the law. And people have got their hands up. Julian, I'm going to Julian.
Hi, thanks, Christine. Julian Webb from Melbourne Law School. Stephen, I really enjoy this. I'm interested also looking at the trajectory of this from the original lecture through. So yeah, I'm a bit of a legal ethics geek. So it's maybe a little bit of the legal ethics geek question in some ways. One thing I think you've avoided going down the path of so far, and I don't know if you see this as an end point or whether it's actually a very deliberate avoidance strategy, because your paper thus far seems to assume there's a little bit of, there's leeway through the onboarding question. Onboarding seems to be your main mechanism so far for dealing with this as an ethics related problem. But what about regulatory change? Are there areas where you would like to see regulatory change at the level of lawyers' regulation? Do you think there's anything that regulation actually could positively do that it's not doing?
It's a pretty short answer, which is, well, yes, but it won't happen. And if it happened, it wouldn't be enforced. So it's kind of the short answer. So I think actually the regulatory framework is pretty good. I don't mind the regulatory framework. I think it does everything it needs to do. I think it tells you be thoughtful. It tells you through lots of situations where active counselling is needed. And I think it gives you permission to walk away in some situations. Now, do I think any of that lands in those ways? No. Do I think the regulator agrees with me? Maybe or maybe not. Will they ever say anything? No. Do they ever enforce against large law firms? No. Do they say it's all behind closed doors? That's why it's not public? Yes. Do I believe them? Who can say? That's sort of where I am. So I kind of think that, yeah, it would be, I could say, actually, what I really like is a very powerful statement from the SRA, which says, these principles mean this, or we're adding in an active obligation in relation to climate change. We're going to change the competence regime, which would be the easiest thing to do, I think. I just don't think they're going to do it. They're so worried about their role. There is quite a bit of regulatory capture. I just don't see it happening, sadly.
If I could come back to my pet one would be around it's the secrecy problem. And I think the confidentiality rule, possibly even some opening up along the way, the ABA have opened up some of the exceptions to confidentiality. So you get a bit more what Christine would call the gatekeeper's justice role being built into the regulation.
Yeah, that's interesting.
It might not make a big practical difference, but I think symbolically.
So I've been working with the IBA on their professional enablers work. And their kind of revised guidance, and it's gone nowhere because that's how public is it? It's pretty public. They got to a place where they had like revisions to their guidance. It was banal. It was watered down so much. I was like, what's the point? And then it went to the European bars, so Germany and other big European states, who said we will veto this. This is totally unacceptable. Even this very kind of banal, boring language that lawyers are sometimes part of a story of doing stuff for their clients. That's pretty much what it said. And they were like, overall dead bodies. And so, you know, kind of, this is the kind of pessimist, sadly, in me. Again, I know I shouldn't be that person. Environmental lawyers are more chipper, I think, sometimes. But yeah, that was cheery again. We weren't behind it. More positive note.
Well, did you have your hand up? And
Yeah,
then Adrian, yeah.
Yeah, I'm Rod Keenan. I like David. I'm not a lawyer, I'm actually a forester, but kind of, I didn't want to be a lawyer when I was in high school. I'm not sure why. Yeah, now looking back. I'm just wondering about the benchmark here, because we're in an economic transition where companies are changing in their kind of activities over time in response to the kind of targets that have been set for climate change. And so how do lawyers make a judgment about, you know, whether a company's intentions are genuine, what sort of threshold? Like AGL at the moment is our biggest emitter, but it's also our largest investor in renewable energy. So should they take work for AGL or not?
Yeah, it's another easy question. Thank you. It's really hard, and I find it really hard for my law students who come to me and say, well, I do want to go and work for this ginormous law firm because I think I can make a difference. And I said, okay, like I don't doubt your sincerity, but actually, when you go into that law firm, you're the very, very bottom of a very, very large pyramid, and your ability to affect change is kind of quite difficult. And I worry sometimes, I think, because I hear this a lot, you know, kind of, it's part of what Emily was saying earlier, you know, we do loads of renewables work for this client, as well as doing this other work, or we only build the fossil fuel plants in countries where that's all that they can do. And these are kind of really hard, like as environmental, but they're really hard environmental questions, aren't they? It isn't, I sometimes make this a bit too black and white to kind of, that's a completely fair point. And when I sort of do it, sort of poke the bear a little bit to kind of make sure that we have the conversation. I'd be much more comfortable if a law firm said to me as a firm, I say, why do you act for BP? They said, well, if you look at all the work we've done for BP in the last 12 months, we've done all of this fossil fuel work, and we don't like it. You know, we don't like it, but we've also done all of this work. And being kind of inside the room has allowed us to have these sorts of conversations, which wouldn't have been possible. If I had those sorts of stories, I'd be relatively okay. I just don't hear those stories. Maybe that is what's going on. And I think also it's the, I'm gonna get Hassan wrong, very gentle, giving voice to values, very gentle, gentile, gently, sorry, thank you. That point about lesser evils, we sort of forget there's an evil and a lesser evil. There's still the evil and the lesser evil. And it's not saying that stuff shouldn't happen. And, you know, I'm so naive, I think the world's very black and white. But I wouldn't mind so much if the law firms did that sort of, but they're not even as partners having those conversations. You know, the renewable energy partner isn't talking to this partner over here and that partner over there.
Adrian had his hand up.
Yeah, thanks. Stephen, in the law students, or some of the law students that I'm connecting with in the climate clinic, I'm starting to see a level of fear and personal anxiety that's mounting greatly. Some of them even showing signs of a real sort of spiritual, existential, the world is coming to an end feeling. Now, I'm sure that's not particular to law students, but for some of those students, it may not be too big a jump for them, some of them, to engage in active opposition that trips over into violence. I can see some of them toying with the idea, even if not actually discussing it openly.
Yeah.
I wonder, how can we offer, in your opinion, how can we offer hope to that sort of student?
I can respond if you'd like me to try to respond, Stephen. So many students, not just law students, but many students are experiencing the same sorts of concerns, and it is a real concern. The Climate Council has a recent report on understanding the concerns and responding to those. And there are a whole range of specific organizations, both Psychology for a Safe Climate, or Psychologists for a Safe Climate, as well as the Climate Council, and I've got to get it right. There's another here in Victoria, group of essentially psychologists and psychiatrists who are providing advice on that. And so the Climate Council report is exactly Beyond Blue, is working with the young people to provide a group of sets of advice. I'm not trying to do it, but I use experts to provide that advice. Psychology for a Safe Climate.
The group in Victoria doing that, huh?
Yes, Psychologists for a
you.
Safe Climate, Beyond Blue, and the Climate Council.
Well, thanks.
They all have resources to address that, and they are well designed by experts in that area.
Also, if they have a lot of energy and enthusiasm to practice environmental law, the EDO have volunteer opportunities, so does Environmental Justice Australia. And if they are disheartened with how they can have impact in this space as a lawyer, with these privileged skills that we have as lawyers, then I'm more than happy to speak to the class, or anyone from the EDO can come in and give them some pathways and have a discussion about options, because we are in a privileged position. It is the critical decade, and there are options still available for us to contribute as lawyers to addressing climate crisis.
Thank you.
I was just going to add quickly in terms of like young people, and you know, it's a very, very difficult space to work in, and it can be very, very hard to find any sort of motivation or hope, inspiration to keep going. And what I've found personally is sort of working with other people who are working in the space and who are also really passionate and, you know, inspiring and are doing something, and talking and engaging with those people can really help.
I'm thinking of the example from the apartheid era where Mandela, starting off as a lawyer, was trying all of these technologies, all these approaches, all this collaboration, all this conversation in an effort to get rid of apartheid. It failed. And he decided he had to deliberately become violent as part of the ANC strategy. If this is as big as a bigger collapse coming as was, you know, apartheid for the blacks of South Africa, this will appeal to some people as necessary, not just optional, but necessary.
Yeah.
Which worries me. But it may be necessary, existentially necessary.
And that's the thing, I think that's why I've kind of been hesitating. I sort of worry sometimes my own sort of practices and the way I teach and stuff. It's very sort of academic in the sense of, you know, you sort of, I do sort of stand back and, you know, kind of think one of the jobs, particularly in the political environment in the UK, is to kind of offer a balanced conversation about something and, you know, I'll give my own views, etc. But, you know, I'm not out there protesting. I'm definitely not tripping over into violent protest. And the sense of despair is, you know, great among my students as well. And I don't have the same sort of resources. I'm interested in them, but I do offer the kind of stories, the kind of, okay, well, there are so many things, you know, things about your spheres of influence. There are things that you can do that will make some difference. Might not be phenomenal. It might not be particularly significant. You may be really disappointed at the inability to kind of bring about the system-wide change. We bring lots of our alum back, which actually helps to have them telling their individual personal stories. But everything you said, I agree with. It's kind of, yeah, it's interesting that the two lawyers I mentioned in relation to Emily, Tim Crossland and Paul Polsland, they're getting to that group are getting to that point in the UK. And what they would like, I think, is the regulators to say that they won't take any regulatory action against them. And so that letter, that declaration of conscience, was the first step, because actually barristers can't do what they did in that letter. They can't say in advance they won't take groups of client. And what they really wanted to happen and didn't was a regulator would have said no. They were going to sue the regulator, get a decision on it, make more action about it. Because that hasn't happened, it sort of went very quietly. They're now wondering what the next step should be. Yeah, it's really tough. And it's tough as well, sorry, in a law school where the majority of my students, and I'm guessing it's the same here, on day one when you ask them, they all want to be corporate finance lawyers. So the students who are having these kind of existential crises, they're a tiny minority. They are actually the ones we tend to find who end up in our clinics. We don't have an environmental clinic, but they tend to kind of group together and be in particular sorts of spaces, and they're very much a minority. So they both feel this sense of dread about the issue, and that they are othered from their kind of peers and the kind of that sort of that potential for fraternity.
I think our students actually want to work for the UN.
Oh, do they? Oh, ask her.
Yes, that's usually what they say.
Did you have a question?
I'm Intezar. I'm a student of Master of Law student. I'm at the University of Melbourne. It's not like a question. So when I did some research on like a public-private partnership, how can help to support the sustainable energy and corruption in climate change, the kind of research that I have done. And yeah, we are talking now about the baryshiters, solicitors, but there are some lawyers who are working for a government. There are some lawyers who are, maybe like legal advisors who are working for like international organizations. If we look like globally, this kind of international organizations, like financial institutions, they are like helping to developing countries to write their like regulations, laws, like they are hiring some experts, some legal experts, for these countries, yes. And maybe as a lawyers, we are like in Australia or in US, I don't know, like in developed countries, like researchers, we need to write some guidance for their kind of legal advisors also, because for example, when I did some research about the corruption in climate change, I found out like a horrible facts, like a lobbying, for example, or conflict of interest. And there is a Transparency International organization, this organization doing some research on this, like among the countries, like developing countries. And if you like do some research on this also, you can see like a horrible facts. So yeah, it's not a good. So my like suggestion, maybe not suggestion, like as a student, like as a little researcher, so maybe we need to help this kind of lawyers also. Yeah, because for example, public-private partnership also can be like an effective way to support the sustainable energy. It was my like findings. It was my finding because when government signs this PPP contract for a long term, so policy can change during a 25 years or 40 years, so it can be like a protect from the corruption risk. So maybe we need to do some that kind of research also. Yeah, thank you.
Yeah, I think that's a really good point. I don't think that work's being done, but I think it's really important. I think two things. One, at the international level, lots of large international organizations employ their lawyers from all over. And it's kind of interesting to me, like what rules or kind of broader ethical norms shape their conduct when you have, one of the UN bodies and you have, because of the requirements, lawyers from all over the world working inside that organization. What is shaping the decision making? And then on government lawyers, I mean, I just think about what's happening at home. At home now we have a situation where the government says that international law doesn't apply, and that government lawyers should be advising as if international law doesn't really apply, even when the government signed up to it. And government lawyers have this new risk document from the Attorney General, which says, even if you think something is very, very, very likely to be illegal in the courts at some point in the future, if there's a chance it's legal, you tell us we can do it. That's literally what the guidance document says. And so when I go and talk to those lawyers, it's so difficult because they say, well, when you're an employee and you have a single client, like, what are you meant to do? And I say in my kind of flippant way, you're meant to walk away. You're meant to realize there's this normative conflict and you're meant to resign, as the former senior civil servant did, Jonathan Jones, and others have done. You're meant to make a public demonstration and walk away. And they said, but I've got a mortgage and I've got children, and I've got life, and I'm trying to make a difference from the inside. But I think it's a really good point. Thank you. Two really good points.
That was beautifully said, Stephen, and I think we might let you out of the hot
Brilliant.
seat
Thank you.
now. So thank you to Stephen. Thank you to Vivian, Susan, Emily, Adrian, and Julia for sort of sharing what you're doing as well. And hopefully we can have more conversation. We do have, I didn't platform, but we do have Rose, who's from our sustainability team at the University of Melbourne, and I know, and Brad here at our law school does a sustainable business clinic as well, and I'm probably missing other things that people, and Julian, of course, that our legal ethics professor here. So that's, in short, a very good reason to all go down to the pub and have dinner together, because there is plenty more to talk about. Except for you Zoomers, you are very welcome to come and join us at the pub as well, but it might be more difficult for you. Thanks for persevering with us online, and thanks to Stephen for getting out of his and I'm going to close off the Zoom now. Okay.